a webinar on the concept of employment law. This is one of a series of seminars that we're undertaking over the spring, covering our core areas of expertise. Previous seminars are available on our YouTube channel, and this one will be today, just in case watching it once isn't exciting enough. My name's David Logan, and I am the Director of Terra Firma Chambers, as well as your chairman for today. Although that sounds quite glamorous, what it actually means is I'm in charge of the slides, so you probably get the wrong ones from time to time. Emma will send copies of all of the slides that you see today to all of those who have registered for this talk after the completion of the seminar today, so don't worry about having to take details down off slides as they flash past. If you're watching this on YouTube, then the last of the slides has all of Emma's contact details, and she'll be delighted to assist you with this. As this is a remote seminar, I don't actually have to warn you about fire exits and matters of that type, but I do want to draw your attention to the Q&A function, which you'll see at the bottom of your screens. If any question arises or think you've anything you want to clarify during the course of the talks, please add that in, and we'll do our best to deal with that at the end of the talks, provided there's sufficient time, and of course, that it's not too hard. The first speaker today is Peter Grant Hutchison. Peter has been a leading light in employment law matters for longer than he would care to admit, with a string of reported cases to his name. Peter also has something of an obsession with TUPE, and he's just bursting to tell us all about it. Here's Peter.
Thank you, David, for that more than generous introduction. Now, why are we talking about TUPE at this particular time? COVID has made many drastic changes. It has made drastic changes to patterns of consumption and patterns of production. With such drastic changes comes transfer of assets. And of course, that is what TUPE is all about. There is also at least some 350,000 employees that are still furloughed or partially furloughed in Scotland. When they return to work, hopefully they will return to work, then it will be a further transfer of assets because some employers will quite simply be undercapitalised. And assets will transfer to those that have the capital to use the assets. And it will be your function, your duty, to advise the employees and indeed the employers when they're doing due diligence and how to accomplish transfers. Now with that, can we have the next slide? You'll have noticed that the title of the talk was The Quiet Revolution. It was initially meant to be 40 years of a quiet revolution. But there are several problems with that title. Firstly, the legal historians will know that TUPE 81 did not in fact come into force to 82, and so the title was always going to be a wee bit of a pothole, because 39 3/4 years of TUPE doesn't sound as good as 40 years. But more importantly, can you have a quiet revolution? Well, I think more accurately what happened with TUPE was a slow revolution. It was on the statute books, it was there, and people quite simply didn't realise its importance. Paradoxically, and indeed with some sense of irony, people only began to realise how important it was with local government changes, local government reform. And initially it was thought that TUPE didn't apply to local government reorganisation. Indeed, our then Prime Minister, who often said that she wasn't for changing or for turning, also really didn't believe that TUPE applied to local government reorganisation. We as lawyers had a really strong suspicion that it did. And in fact, myself and many others went into judicial forums and argued that TUPE didn't apply because that was our instructions, that's what we had to do. COSLA wasn't giving any lead on it, but we knew it was going to apply. And indeed, can you call it a revolution? Well, it was. It was a seismic change in employment law. I started practicing in 1981 as a solicitor, almost straight into doing employment law. And as at 81, there was no concept of having continuing rights in your employment, no prospect of transferring to where the assets were. You could have worked for one employer for 20 odd years, helped build up the business, but when he changed, the business ceased, then so did your employment. Not a true redundancy situation as we would know it today, but nonetheless, the employment did cease and nothing to show for it. And that's why that last slide that was there before David changed it showed a group of miserable people standing there because they had no protection. And the purpose of TUPE was to provide that protection. When assets went in one direction, the employment contract should also go in that direction. And it was a creation of Europe, of European legislation. TUPE 81 was there to implement as the Acquired Rights Directive. It was the domestic attempt to implement it. And the Acquired Rights Directive said it was there to provide further protection of employees in the event of the change of an employer, in particular to ensure their rights are safeguarded. So we have, can we go back a slide, David? Seen that one, sorry, go forward again. This is a summary of what was hoped to be achieved by the original TUPE protection. Now you'll see at the top that it refers to regulations 2006. Well, TUPE morphed from 81 to 2006 by way of amendments and changes. But we see there what was hoped to be achieved. Let's move on to the next slide, David, if you would. Now we see the first bit of that 3.1a. That is the part of TUPE which reflects the Acquired Rights Directive and what Europe was trying to achieve. Second part, 3.1a, 3.1b, was new, and that is UK legislation. And we'll come to that in a moment, because there's a difference in how we interpret these types of legislation. You'll see that 3.1a refers to an economic entity. That was the key question that dominated so much litigation. What was an economic entity? Europe said, well, it's going to be protected, the transfer is going to be protected, it has to be an economic entity. What is that transfer? If it is capital intensive, look at where the capital has been transferred. If it's labor intensive, look where labor has been transferred. Has it retained its purpose? Has there been an interruption of the business? Has there been a fragmentation of the business? These were all the type of things you had to look at to see if there had been a transfer of an economic entity. And to this day, I do at other council get opinions, and I'll ask, do we believe this is a transfer of an economic entity? Still a matter of dispute. Let's look at a practical example. Case of Lightways Contractors Limited v. Associated Holdings. This is to be found in 2000 session cases. It was an inner house decision. What happened? There was a retendering exercise for repair work and provision of street lighting. Lightways won the contract. Lightways did not take on any capital equipment, and yet it was capital intensive. It had its own equipment. It had a slightly different method of carrying out the repairs. Employment, well, there's quite a lot of employees, and it did take some of them on, but only after interview, not as of right. Now, was that a transfer? What do you think? Before you rush to answer, let's add something else into the melting pot. When Lightways made its tender, its successful tender, it said, oh, and we think TUPE will apply. Now, is that a factor which would influence your decision as to whether an economic entity has transferred? Well, their lordships said that it was. They said some weight could be given to a party's intentions. But Lightways saying, yes, I think. Now, also think about that decision. You can't contract out. Why should you be able to contract in? Is that truly a legitimate factor? And it's something that you may find yourself arguing in the future. Why am I citing this case today? Because I was in that case and I lost it, and I'm still aggrieved after all these years, and I'm seeking your sympathy. But no, more importantly, much more importantly, it's a useful case because what happened was clearly a service provision, but it came within the ambit of the original regulations and was held to be a transfer of an economic entity. So 318 isn't gone, it isn't lapsed, it's still effective for service provision changes as well. And just to redeem myself a little, I may say that there was a dissenting judgment, one of their lordships, me in that case. But moving on just a little. If 318 can cover service provision changes as well, why do we have service provision changes? Isn't there at all? Isn't that a bit unnecessary? Well, it's there largely because UK courts and people that make the law got frustrated with Europe because Europe was being very far from being consistent in how it approached service provision changes. In about 1994, there was the case of Smith. Smith was a cleaning lady. Her sole capital was a mop and bucket. And she lost her cleaning contract. And she said, can I have TUPE protection, please? Well, not TUPE, but Acquired Rights Directive protection. And the European Court said, certainly, madam, we will protect your employment rights. Acquired Right Directive will apply. 3 years later, in the case of Susan, very much the same facts and circumstances, very similar. And indeed, all the cases that were cited to the European Court in Schmidt were cited again in Susan. And the European Court came to a different view and said, just because a contract is lost, doesn't mean to say acquired right directives. With this degree of frustration, enough is enough. UK gave its own protection to service provision changes. That's outsourcing, tendering, all that type of situation. That is what meant by that. Now, I think I have to give you a word of caution. When you're looking at these slides now or later, please also look at the statutory instrument, because these are truncated versions of what the regulations say. So for your own protection, please look at the statutory instrument. But when I came to remind myself about definitions under Regulation 3, I couldn't help but notice that all the bits that continue on from the slide are a rehearsal of all the European cases about service provision change. So in many ways, 3.1b, although it is UK legislation and has to be interpreted by our own canons of construction, It's actually just a codification of what was happening in Europe. All right. We have all this protection. I will now going to skip over Regulation 4 and Regulation 7. Regulation 4 shows the effects of the relevant transfer, what it does, what actually transfers. And Regulation 7, we'll move on a little, David. Regulation 7 basically says there's a dismissal because of the transfer. It's unfair, except there's a defence. You'll see the defence. Move on. We've got all this protection for a very happy workforce. I use cartoons basically because if you looked at it in real life, we'd see a very different situation. We'd see the misery that is there if there isn't TUPE protection. Cartoons tend to protect us a little bit. But at least there is protection, or at least in theory, there is. Can we look at the next slide? Not all problems are curable. Remember talking to a councillor once about councillor, and I said as elected official, not any other form of councillor. A councillor saying to me, well, you can have all the rights and duties that you want. No jobs, there are no jobs. And of course, that is right. No one wants to buy the assets. No one wants to take on the employees. Can't be much protection. So in an insolvency situation, TUPE will not apply. But therein lies lots of litigation and lots of arguments. I think what we can say after a whole series of litigation is that this is just broadly a rule of thumb. If a company is in administration, then TUPE will probably apply because it is the administrator's duty. It's part of the statutory definition, almost, that is to try and make the business effective to run the current trading. TUPE will apply. If a company is in liquidation and the liquidator is simply realizing the assets, then TUPE will not apply. Pre-packed administration, TUPE will apply. It's envisaged that something will be trading almost from the very beginning. There's still room for some litigation and argument about what happens with provisional liquidators, but generally in insolvency, there is no TUPE protection. Well, with that, we are about to enter very difficult times, very changeable times, and we will be relying on European legislation even more. Have the last slide, David. Next one, please. But you'll have noticed we've had Brexit. In this time of great uncertainty, are we without guidance? Are we without assistance in relation to TUPE? Gone when I needed you most? Well, perhaps not. I'm going to resume this talk a little later. In a moment, I'm going to hand you back to David, and then we're going to hear from David, and we're going to hear from John. And as I said to David earlier, with just a little exaggeration, he can give himself a wonderful introduction to his talk. And he need not exaggerate at all when he gives a wonderful introduction to John's talk. Pass you back.
Thank you, Peter. My short talk today is called, as you can see, Post-COVID Economic Realities for Employers. And in preparing this talk, I remembered President Johnson's observation that talks about economics were a bit like peeing down your leg, which is a somewhat coarse man. He said it felt pretty hot for you, but it didn't do an awful lot for anybody else. And so you'll be probably not too distressed to learn that it's not my intention today to lecture you about the implications of modern monetary theory or why quantitative easing has not managed to result in inflation in the post-COVID era, fascinating though those topics are. What I want to do instead is to concentrate on how The economic relationships and the economic realities are now determining the extent of rights that are being given in the employment field and in particularly tribunals. Now, we're not unfamiliar. Sorry, do something here. Not moving. Yes, we're not unfamiliar with the idea of employment rights going beyond employees directly, and we're all familiar with the provisions of Section 230 of the Employment Rights Act 1996, which introduced the sort of European concept again of a worker. And really, the point of this was that it extended rights beyond those who would be regarded as employees. And in particular, I would draw attention to subsection B, that we see there, which is that someone under any other contract, whether express or implied, and whether it's in oral or in writing, where the individual undertakes to do or perform personally any work or services for any other party to the contract whose status is not by virtue of that contract that of a client or a customer of any profession or business. So we don't become employees or workers simply by doing work for our clients carried out by the individual. So that is the concept of a worker, and certain rights are given to workers, for example, minimum wage legislation and rights to sickness and holidays and so forth. And these rights, the question then applies as to when these rights apply and when they don't. And of course, in recent times, we've had the decision in the Uber case, which we'll be familiar with, Uber against Aslam from earlier this year, where the court made a decision that people who were providing taxi services through Uber were workers for the purposes of Section 233B, and therefore had the protections and the rights that came with workers. Uber was not the first case of that type, I have to say, though. AutoCleanse Limited, which the court relied on quite heavily, was an earlier case where the Supreme Court upheld a court appeal decision in relation to people who provided valeting services for a car sales shop. And they had a contract which basically said they were not workers. And the question was, well, what happens then? What do we do when there's this contrast between what looks like the reality and what the contractual arrangements between the parties actually said? And the Supreme Court in AutoCleanse said that this could be overlooked. And I think that was possibly a turning point in terms of the balance of power, if I could put it that way, between the contractual interpretation of contracts of employment and contractual rights and those which are simply based upon legislation. The Uber case has picked that up and really taken it to a different level in a way which I think is very significant. They have emphasized that what we need to look at is the actual economic realities of the situation, and it doesn't honestly matter that much exactly what the parties have agreed. Lord Leggett put it this way. He said, critical to understanding the AutoCleanse case as I see it, is that the rights asserted by the claimants were not contractual rights, but were created by legislation. Thus, the task of the tribunals and the courts was not, unless the legislation required it, to identify whether, under the terms of their contracts, AutoCleanse had agreed that the claimants should be paid at least the national minimum wage or receive paid annual leave. It was to determine whether the claimants fell within the definition of worker in the relevant statutory provisions, so as to qualify these rights irrespective of what had actually been contractually agreed. In short, the primary question was one of statutory interpretation and not contractual interpretation. And that is certainly based upon the AutoCleanse case, but in my view takes it somewhat further. It's also, I think, important to realize that that statutory interpretation is purposive. That is, it is designed to be an interpretation that facilitates what the legislation is designed to achieve. And if Peter had had the benefit of this kind of dicta in 2000, his case in the Lighthouse case may well come out somewhat differently than it did, because the thinking at that time was somewhat different. So what we have in these types of cases is a situation where the courts are basically not that interested in what's in the contract. What they are interested in is the facts. And that obviously impacts very significantly from a practitioner's point of view in terms of how the case is going to be presented at tribunal. You really are looking to draw out the evidence that makes sure that your person and the economic reality falls either in or without the worker, depending which side you're arguing that particular day. So that is one example of where the legislation has now become the dominant feature in terms of the way that relations between employees and employers, or those to whom they're providing services in a more broad sense, are applied. Another example, which I've come across very recently, is the issue of the what's called the Construction Industry Training Board. They have a levy which is used to pay for apprentices and training in the construction industry, and that levy is payable by anyone who basically has more than 50% of their work involved in construction. The definition of what's meant by construction is in the an order which was granted in 2015, which is called the Industrial Training Levy Construction Industry Training Board Order, and it's a very, very broad definition of construction. So surprising numbers of people are caught by this provision. But the range of companies that are caught by this has actually been expanded very considerably by the decision of the Court of Appeal last year in the case called Hudson Contract Services Limited against the Citb. And what had happened in that case was that Hudson, who were really middlemen, what they did was they got people who wanted some bits of building work done or repairs done to properties. They would, if they contacted Hudson through their call center, they would be put in touch with contractors locally who were approved, who were deemed to be of a sufficient standard and quality, on whom they could rely on. Those householders then entered into their contracts directly with the contractors, and Hudson were not a party to those contracts. Obviously, they were getting a commission, but they were not a party to the original contract. They had nothing to do with the construction work whatsoever. And so when they were assessed for the levy, they were somewhat astonished, because as far as they were concerned, they didn't employ anyone to do construction work at all. They had no people involved in construction. What they had was essentially a call center. And the Court of Appeal disagreed with that. And the reason they disagreed with that is that they were taking a broader definition of the people for whom Hudson were responsible. And the definition in this case was not just people that they were employed, not just workers, but people who were providing services in the form of construction through them to other parties. Now, again, you might say, well, in this case, surely they weren't actually providing the service, but that was deemed sufficient to bring them within the legislation. What Lord Justice Smiler said in the Court of Appeal was that I'm in no doubt that the governing concept is the concept of an employer in the industry and on whom the liability is imposed. Although it is true that the 1982 Act does not define the phrase employer in the construction industry in a compendious manner, instead of defining both employer and the industry separately, I do not accept Hudson's argument that these are legally and factually distinct concepts that must be answered in two different stages. To determine whether liability, this is the part on the slide, to determine whether liability is imposed on a particular person, the statutory question in both the 1982 Act and the 2015 order is whether the person is an employer in the construction industry, and not, for example, whether it is a company, business, or establishment in the construction industry. The result of that, for the purpose of the levy, was that Hudson were deemed to be an employer in the construction industry, even though they had no one doing construction work. Now, since that case, there's been quite an aggressive expansion of by the Citb of the number of companies they think fall within terms of the levy, and quite a lot of development companies in particular are getting caught up in this. And as I say, I have a case of this type at the moment. There are some interesting questions that arise as to how you measure how many employees you actually have in the construction industry when they're not your employees, and you don't know how many these subcontractors or subcontractors even employ. I'm not sure there's a clear answer to that yet. But what I have done and suggested in the case that I have been involved in, and which the Citb have accepted for the purpose of that case at least, is basically follow the money. So we've looked and said, well, of the money, of the turnover of the company, what percentage of the turnover of the company is construction work as falls within the 2015 order? And that's an exercise that's being gone at the moment. I think that's the sensible way to deal with it, but I can't say that's the legal authority because, as far as I'm aware, there just isn't one. What these two lines of authority both have in common, in my opinion, is that the courts are no longer interested in the contractual concept of employment in the way that they were 20, 30 years ago. they're much more comfortable that their job is to apply the statutory framework to the economic realities which they are presented. It's interesting that the courts have gone this way, I think, in employment law, at the same time as we've been going back to a much more textual analysis in terms of contracts and contractual interpretation for cases like Arnold against Britain, for example, where we're very much looking back to the words, read the words, as I think Lord Hope put it, rather than getting this purposive approach or this statutory approach, we're going in two different directions in two different areas of the law. As I say, I think from contractor's point, from an advisor's point of view, what we need to look at is how do we present the cases? And I don't think, spending a lot of time and effort in your either drafting the contractual terms or in bending your arguments around that at a tribunal now are going to have a lot of success, because what you really need to be looking at is the statutory provisions of the type that Peter's been talking about and that John's about to come on to in relation to his case, rather than anything that's supposedly agreed between the parties. The court's much happier, in fact, will just automatically now look behind the supposed agreement to see what the reality is. So a different approach in employment law, a different emphasis on terms of economic realities. What I'd like to do now is pass us on to our next speaker, who is John Kiddie, who's overcome the considerable disadvantage of being my devil last year, to build a flourishing practice in difficult times with a lot of issues on public law and some issues in relation to employment. He's going to address the Mencap case, and without giving too much away, you definitely want to stay awake for this one.
Thank you very much for that very kind introduction, David. Contrary to his modest comment on my being at disadvantage by being his devil, I did actually learn a great deal from David, and I'm still doing so. In fact, if he were entirely candid, perhaps he would confess that it is he who has encumbered himself with the previously unforeseen burden of a devil master's after-sales care to his erstwhile pupil. In any event, let's move on to look at Mencap. Mencap is just one of a series of important judgments recently delivered by the UK Supreme Court in the field of employment law. Just this year, on 19th February, the court gave its judgment in the Uber case, which David already mentioned, and which has already been the subject of much discussion at large in respect of the question of worker status. Then 1 month later, on 19th March, the court gave us Mencap, the case I'm going to discuss in respect of sleep-in shift workers' right to the national minimum wage. Then a week after that, on 26th March, it gave us ASDA against Brearley, which will also likely be much discussed in respect of equal pay. All three of these judgments are extremely important for employment law and employment law lawyers. Therefore, this has indeed been an exciting time for us in terms of UK Supreme Court decision-making and direction. However, it's also been somewhat up and down depending on your perspective. Where the Uber and ASDA judgments tend to favour employees and workers, while broadly speaking, Mencap is more favourable for employers. Could I have the next slide, please, David? We're waiting for the next slide, but in any event, well, here we are. Thank you. It's the one with some statistics on it, that one. Thank you. As said, Mencap focuses on the right or otherwise of nighttime sleep-in workers to receive the national minimum wage. The minimum wage, of course, forms part of our law in terms of the National Minimum Wage Act 1998, being the framework statute with various sets of regulations laid into law under it, of which the 2015 regulations are the most recent consolidating version. The two cases that led to the Mencap judgment came from the care sector. Thus, the judgment is extremely important for that industry, and that industry itself, as we all know, has become crucially important for society at large over a long number of years, and is likely to become even more so as life expectancy improves. However, Mencap has broader application and wider reaching implications across all sectors of industry that employ nighttime workers. Therefore, in this slide, I want to put this into some kind of context in terms of statistics. The first stats are slightly out of date. They go back to 2018. However, we can see from these TUC figures that over 3 million UK workers engage in nighttime work. That's over 11% of the entire workforce. And this trend is increasing, with a 5% increase between 2013 and 2018. And out of those 3 million, 2/3 are women. And it is also common knowledge that many care workers and other nighttime workers tend to be low paid, and many only receive the minimum wage. Meanwhile, the minimum wage has just gone up. It's now £8.91 per hour for adults aged 23 years or older. This coincides with the government's living wage, which is effectively the same as the minimum wage for adults. For current purposes, we can effectively disregard the Scottish real living wage, which is higher, but as a political creature is legally irrelevant. Yet nonetheless, we can also see from the Low Pay Commission's figures that 2 million UK workers receive only the minimum wage or lower, and the figure for Scotland is 150,000. Many of these workers and their employers will be nighttime workers, thus affected by Mencap. And in terms of the potential financial impact for employers, we need only look to Mencap itself, to the judgment itself, where one of the appellants was claiming £240,000, almost £250,000. That's a single claimant whose claim consisted of allegedly unpaid wages accruing over a number of years. And this is typical of such claims. Thus, where a number of claimants band together, the overall potential cost to employers could easily spiral into millions. Could I have the next slide, please? So now let's turn to the actual judgment. It concerned two conjoined appeals, both of which had previously been heard by the Court of Appeal. The first case was that of Royal Mencap Society against Tomlinson Blake, from which the judgment derives its commonly known name. The second case was that of John Shannon against Clifton House Residential Home. We'll look at the actual facts in a little while, but before I get to that, I just want to make the point about the timing of the judgment. The appeal itself was actually heard by the Supreme Court in February 2020, in other words, pre-COVID. The reason, as I understand it, for the length of delay between hearing and judgment is that the justice originally assigned to write the lead judgment was Lord Kerr, who unfortunately died last year. Therefore, this task was reassigned to Lady Arden. However, the consequence of this is that by necessity, the court could not give consideration to any issues as might arise out of the pandemic, even where these might be relevant, where of course many workers are affected by being required to undertake more nighttime work or are working from home. And Lady Arden makes this point at paragraph 74 of the judgment, which you can see on this slide. As said, unlike the Uber and Asda judgments, which were pro-worker, the effect of Mencap is more pro-employer. Thus, its effect essentially turns on its head much of our previous understanding of the law, and indeed the court specifically overruled a number of important opinions of the lower courts, including the English Court of Appeal and our own inner house. Could I have the next slide, please? So you see here that I've listed the principal overruled opinions on this slide. And these include the leading Scottish decision in Scotbridge Construction against Wright, which itself had been decided on the basis of the Court of Appeal's opinion in the British nursing case. Could I move on to the next slide, please? So if we now turn to the facts of the two individual cases considered in Mencap, the first was the Tomlinson-Blake case. Now, this concerned a time care worker. In other words, she was paid per hour at an hourly rate. Her job consisted of providing 24-hour domiciliary care for vulnerable adults, and she was paid her hourly rate for the time she spent in their home during the day, and that was consistent with the minimum wage in terms of her contract. Yet also in terms of her contract, when it came to night time, she was expected to sleep over at the client's home, yet was only paid an allowance of £29 per shift. This was despite the fact that, as she put it, she had to keep a listening ear even while asleep. To listen out, in other words, for any eventualities that might require her to wake up during the night. Because she was a time worker, her case turned on the court's interpretation of Regulation 32 of the 2015 regulations. And she actually won at both the Employment Tribunal and the Employment Appeal Tribunal, only to have those decisions overturned at the Court of Appeal. On the other hand, in the other case, in Mr. Shannon's case against Clifton House Residential Home, it was somewhat different. He was employed as a salaried care worker, and on the appearance of it, he actually had quite a good package from his employers. They provided him with accommodation free of charge, including utilities free of charge. He was entitled to live in that accommodation during the day, although he could come and go as he pleased, all rent and mortgage free. He was only actually required to be there at night, but when he was there at night, he was allowed to sleep. But he had to be available to help the dedicated night care worker if called upon to do so, if anything occurred during those hours, which in fact it seldom did. Eventually he was dismissed, whereupon he claimed several years of back pay amounting to, as I previously said, almost £250,000. Because he was salaried, his case turned on Regulation 16 of the older regulations of 1999, and that was because of the timeline for his case. Perhaps somewhat unsurprisingly, Mr. Shannon, unlike Claire Tomlinson-Blake, lost at the Employment Tribunal and Employment Appeal Tribunal, and like her, he also lost at the Court of Appeal. The Court of Appeal heard both their cases together. Although each turned on a separate provision, nonetheless, the essential issues were the same. When the UK Supreme Court came to consider these cases, its approach was very much, as David has already suggested, along the lines of statutory and regulatory interpretation, as opposed to contractual or contextual analysis. And in a sense, the judgment that the court reached is really predicated on its plain reading of the words adopted by the regulations. If I could move on to the next slide, please. You'll see on this slide, I've included the wording of Regulation 32 of the 2015 regulations as an example. Regulation 16 of the 1999 regulations dealt with salaried workers in that timeline. Its wording is somewhat different. However, the essential issues for the court were the same. Thus, the court was largely uninterested by certain contextual or contractual arguments the parties attempted to present. For example, the argument that where some other law requires an employer to ensure a minimal number of workers are physically present at a workplace, then those workers are available for work and should be paid the minimum wage. The court considered that to be irrelevant. Can I have the next slide, please? So the court really just looked at the wording of the regulations, and in particular, it drew a crucial distinction between a worker actually working on one hand, and on the other, being available for work. The only substantial other source of guidance that the court would permit itself to use for context was the reporting of the Low Pay Commission, and it only did so because the LPC actually serves a statutory function under the 1998 Act. Although the LPC had existed before the Act, it's the Act that puts it on a statutory basis. The Act confers on it the role of reporting to the government for the purpose of setting the minimum wage, which government in turn reports to Parliament. And while government has the option to derogate from the LPC's recommendation, it would have to put Parliament on notice of any such derogation, and in fact has never derogated. Therefore, the court treated the LPC's reporting as legally relevant for interpretative purposes. In a sense, it made it its concern to apply the statutory framework as the will of Parliament, albeit as expressed in the form of subordinate legislation laid into law by government. And in overruling said previous court decisions from the lower courts, the UK Supreme Court observed that the lower courts had not been referred to the LPC's reporting. So in a way, it kind of let them off the hook for having got the law wrong before. Have the next slide, please. So Mencap is helpful, particularly in clarifying the law and particularly for employers. However, it's not absolutely definitive. The court has still left the light on for other claimants to attempt to bring a case where they can argue that their facts should be distinguished. And if you could have the next slide, please. This is reflected in paragraph 57 of Lady Arden's judgment. I'll just read the highlighted part of that for you. She said, "Not every worker who is permitted to take a nap between tasks is a sleeping worker, and a person may, depending on the facts, be working as opposed to being merely available for work." In other words, you might be at work and have a nap on the job and be permitted to do so, yet not necessarily fall foul of the Mencap judgment, and thus still be entitled to the minimum wage. There are also other potential arguments that might be made. Mr. Shannon attempted to introduce one. It was the court wouldn't have regard to it because it was essentially a new ground of argument. It didn't dispose of it on its merits. And also, as said at the outset, Mencap doesn't deal with situations that might be COVID specific. Thank you very much for listening to me. This is my last slide. Therefore, I would like now to hand you back over to Peter for some more of his wisdom.
Peter, you need to.
Thank you for that, John. Forever the optimist. I will try and share my wisdom. You recollect that before we had these two excellent talks, we were talking about whether European law was still with us or not. Can we have the first slide? Obviously, the slide may not be with us, but European law still is. There we are. But we have to remind ourselves that it's not the same European law. It's not quite the same as the law we were referring to previously. The law has developed. The Acquired Rights Directive was giving primacy to the interests of workers when there's a transfer of assets. Workers' rights had to be protected. That is still true. That's still true. But since about 2014, the debate in Europe has been slightly different. What has been said is that greater emphasis must be given to the rights of the employers, not quad against the employee, but in relation to each other. When there's a tendering process, when there's transfer of assets, transfer of contracts, look at the justice between the two employers. And if we look at the next slide, there was a case of Goverts. Now, what happened in Goverts was applying the Acquired Right Directive. There was a manageress, I think, in Kent, and she had worked under 3 part-time contracts. There was a retendering process, and 2 of the contracts went one way, and third contract went the other, and she says, I want protection. Now, applying the UK service provision changes, the UK legislation, what we would have done is we would have said, well, if most of the work is going with the 2 contracts, then that's where she should go. That would be the relevant transfer. That's where she should get protection. If, however, there were lots of different transferees, lots of different contractors, huge amount of fragmentation, you might have said that there was no transfer. That would have been the UK position. But Europe said, no, Ms. Goverts, you will have protection, but in a way that the UK would find a little unusual. It said, there's no harm in having, no problem having mini contracts. If you spent 20% of your time in duties with one contract, then you get protection for 20% following that contract. And so it goes. You just break it down as to how your work was allocated. That's what Europe said. Now, this proposition came to be tested in the case of McTeer contracts and MITI property services. And it came about in a manner that I'm going to describe to you in a moment. But as an aside, it was Lord Fairley that decided this case at the AAT, Employment Appeal Tribunal, an excellent Court of Session judge. And I'm not saying that just in case you might be looking at YouTube a bit later. I mean that, a very good judge, and one with a lot of employment law expertise. He was an employment judge at first instance for a considerable period. Came before him. And what had happened was that a local authority had put out for tendering some considerable time ago, many years ago, an outsourcing exercise whereby kitchen maintenance and kitchen installation was being done in social housing. And I think it was Amy that won that contract and had been doing it for years. And it was doing it on a non-geographical basis. Just worked within the local authority area. There are 2 teams of about 20, I think, 2 teams, but they could work throughout the entire area and not allocated to any particular part of it. On retendering, the local authority said, no, we want 2 contractors to do it, not just one. And the one that wins the first bid will get part of it. One that comes second will get the other part of it. So that was McTeer and MITI. So how did this case come about? Well, McTeer and MITI said, TUPE doesn't apply. That's how a lot of these cases happen. The new contractors, transferees say TUPE does not apply, we're not bound by it. And they said, and if we are going to have to implement it, then it won't be in the same terms and conditions. A lot of the employees put forward claims initially for holiday pay, notice period, redundancy, unfair dismissal. And there had to be a preliminary hearing to decide who the claims should be directed against. Was there a TUPE transfer, and who was it transferring to? And Amy, as a matter just of practicality, had created a schedule which had worked out which team had spent more time working in the north and which team had spent more time That wasn't the original basis on which the work had been done, but this was just a statistical exercise. And Amy said, well, just for convenience and to give something for the regulations to bite on, these employees should go to McTier, these employees should go to McTier. The employment judge at first instance, applying the service provisions, which was a UK statute, which is open to UK interpretation, regulation rather, said, yes, there's some merit in that. I think that works. And we will transfer, that's who the claims should be directed against, in that proportion. It went on appeal to the AAT, and prior to being heard in the AAT, the Govert's case was promulgated. What did Lord Fairley do? He didn't have to be bound or influenced by the Govert's case, because that's European purposiveness approach. It's not UK statutory approach. It's not the same bit of the regulation. We look at the next slide. Lord Fairley was influenced by certain arguments. And the first one was that when you look at the effects, Regulation 2, which says the effects of a transfer, it doesn't actually distinguish between what type of transfer it is, and a business asset, economic entity transfer, or a service provision change. And if you don't distinguish and remedy, aren't you just confusing matters? You don't apply the same law or the same way of looking at the interpretation. He also said that there was nothing in the previous case law to prevent a Govert's type approach. And he also looked at the legislation itself, which gave the authority for the introduction of the service change provisions, and said that act refers of itself to the generality of TUPE. And that's a strong indication that we should really be working on the same approach and the same jurisprudence in the case. So when he came to look at these matters, he said, no, Govert's should apply, and he referred it back to the employment judge at first instance to apply Govert's. That's an entirely good legal analysis. On many levels, it works. I don't, however, envy the employment judge for instance, and I don't envy you as advisors, either to the claimant or when you're doing due diligence and have to advise on the tendering process. Because what we have now, after this case, is the concept of mini contracts. Right, you have 80% of your time worked on the north area of this authority, 20% of your time in the south. Applying that rationale, perhaps 4 days a week should be spent working for MITI, 20% for McTier, or whatever. So that is 4 days, 1 week, 1 day, 4 days and 1 day. Who gets to decide which 4 days you work? Which is the 1 day you work? Who pays the travelling expenses? How does that apply when you have 6 or 7 or 8 transferees? What sort of fractions are you working on? And of course, these are competitors. These have been people that employers have been competing for the contracts. How far can they be expected to cooperate to make sense of all of this? And it has been suggested that when you're doing due diligence, is what you must do. You should really talk to your competitor. But what if there are restrictive covenants stops an employee working for one competitor and then going to work for the other. That's the purpose of the restrictive covenant. Stop that. And let's say that you're fortunate enough to come to a level of agreement. Let's say you and your competitors and the employee all come to an agreement as to what should occur. Think about it. Isn't that just a way of contracting out the legal effects of TUPE? And that is something you're not allowed to do. And it also strikes me that if you're in any management role and you're splitting it up, that management duties between 2, 3, 4 employers, then you're bound to be diminishing your importance, the importance of your duties. There is going to be an adverse effect on the rights of the employee. That may trigger a TUPE itself. These are all the complexities. Can we look at the last slide? Poor Humpty Dumpty went to bed on a Monday night. An employer. He woke up on Tuesday with 6 employers or 7 employers, all with many contracts of employment. Well, the employment judge at first instance is going to have to put them together again, but I strongly suspect only their lordships. Now, with that, I am going to bring this talk to an end, but I must say, there are a few certainties in life, death and taxes being unpleasant ones. We have, however, some certainties. European law will be with us to assist. TUPE will be there to assist. They will have their complexities and difficulties, but terra firma will also be there to help you with those difficulties. I'll pass you back to David.
Thank you, Peter. Trying hard to get the slides to move again, not succeeding. I don't think we'll honestly we have time for the questions and answers today. I'm sorry about that. We do seem to have used up all of our time and indeed gone slightly past it. I do want to mention briefly in passing that there are more seminars planned on property law, on public inquiries, I think with the first one, and on planning, and the details of which can be found on our website. But we are slightly over our hour today, and I would want to thank you all very much indeed for listening. Thank you very much. Bye.